Kit, thank you very much indeed, and nice to see a lot of familiar names and faces from previous representations. So good to see you all, and I'm really pleased to be here today. I'm going to talk. I think I was originally asked to talk about the new bill and how that will affect protest work law. And I am going to still end up on that, but things have been changing fairly quickly in relation to protest law, with a number of cases that have gone on in the courts in the last few months. So I thought I'd spend a little bit of time on that, and I've got some slides. Now, you may have to bear with me, as I'm not the best at technology. So I'm going to try and share this screen. Hopefully it works. Can you see the first slide, your right to protest? Yes? Yes, great.
Yes.
Okay. So there's a few slides here, and what I'm going to do is just go through, because in essence what we're talking about is your right to free speech, your right, fundamental human rights under the European Convention on Human Rights, and indeed under common law. I'm going to just talk a little bit about that and talk about a few of the common offences in very brief terms, and then look at necessity that many of you have previously talked about, look at the new case of Ziegler, and then round up on how the bill may change things. So I'm going to start off with going back to basics. Why is free speech and protest important? Because it's the way that we change things, really. It's the way that all of you know, and that we know. It's how society changes. And the quote here is from the High Court in Ziegler, in fairly colourful language, which says that there were 4 elements to why free speech is important: about the autonomy of the individual, the discovery of truth in the marketplace of ideas, and this idea that history teaches us what begins as heresy may end up being as accepted fact and indeed the orthodoxy. And often you'll have heard me in court before talk about the suffragettes being an example of where what they were saying was vilified at the time, and now you can't get a mainstream politician that can't associate themselves quickly enough with the suffragettes. It's essential to the proper functioning of a democratic society, and it helps maintain social peace by permitting people a safety valve. And that's how change occurs. And that last one is probably, in a way, the most important. It's how change occurs without, or at least reducing, the risk of violence and disorder. And it wasn't a revolutionary, but an American president, John Kennedy, that said, those that make peaceful revolution impossible make violent revolution inevitable. And that goes to the essence and the heart of why free speech is such a key part of our democratic tradition. Now, there are offences then that the police and the state uses to restrict our right to free speech. And I'm going to go through these fairly quickly because they may be familiar to many of you. Obstruct highway, perhaps the most common, one of the 2 most common for cases, demonstrations for XR. There has to be an obstruction. It has to be willful. You have to be deliberate. It has to be on a public highway. And what I used to put in here was that it has to be an unreasonable use of the highway. Well, that's changed now. The terminology of how we say all of that is now different. It now is for the state to show that their interference with your right to free speech was not disproportionate. And I will come back to that shortly, because that's what's changed. That is what is a game changer in the case of Ziegler. Aggravated trespass, spelt wrongly, but it was done in a rush. Trespass on land, so it's about protecting private property. Somebody on that land has to be doing some lawful activity that the defendant has to intend to intimidate, obstruct, or disrupt. And that's what makes out the offence on aggravated trespass. Criminal damage, that without lawful excuse, you intend or you're reckless to destroy or damage property. Lawful excuse, be protection of property, i.e. you're protecting property elsewhere, that you believe that the property that you're destroying or damaging, that the owner or the person in control would have had consent, or that you're exercising your Article 10 and 11 rights. One of the arguments in that exercising Article 10 and 11 rights that we've been trying to run quite a lot in XR cases is this idea that if it's temporary damage, then that can't constitute criminal damage. Now, there is case law to say temporary damage is damage within the Act, but there are certainly examples that we've won by trying to use the Human Rights Act to show that that's not appropriate in convention terms anymore. Then again, something that'll be familiar to many of you, when the police impose orders on demonstrations. Section 12, Section 14. Section 12 is for processions. Section 14 is for assemblies. So the police can impose those by the senior officer, believing that it's necessary to prevent serious public disorder, serious damage to the property, or serious damage to the life of the community. And it's that latter one that should be serious disruption, really, to the life of the community. It's that latter phrase that is often used to justify conditions. Conditions are limited to restricting the place, maximum duration, or maximum number, but that's only for assemblies. For Section 12, for processions, it can be any condition that the police feel is necessary. But most importantly, it's not for future demos, particularly for assemblies. And XR won a very, very important case in the, I think it was October 2019 rebellion in relation to that. Public nuisance is the one that is perhaps more concerning. All the ones previously. Obstruct highway is non-imprisonable. Aggravated trespass is imprisonable up to 3 months, but generally people get conditional discharges or fines. Criminal damage is imprisonable. If you damage above £5,000, then you can get a Crown Court trial, but generally non-imprisonable. Section 12, 14, non-imprisonable. Public nuisance is an offence that officially attracts a life imprisonment term as a maximum. Nobody will get that, but it is certainly where you are more at risk of a prison sentence. And those are the range. Public nuisance hasn't really been used very much, partly because the way that the law has developed in public nuisance means it's really difficult for the police to use it. They can only use it where none of these other offences are appropriate. So if you are blocking a road, then you will recall, I think in the last rebellion, a lot of people got arrested for public nuisance. But actually, what the courts have previously determined is if there is an adequate offence that Parliament has determined, such as blocking a road is obstruct highway, then normally you should charge that offence. And what you shouldn't rely on is the offence of public nuisance, which is what's called a common law offence, which has been developed by judges. And if there's a choice between the two, then Parliament takes precedence because Parliament has determined that, for example, obstruct highway is a non-imprisonable offence, and you can't, because the CPS want to, simply convert it into an offence that would normally send people to prison because they want to. There are limits to that. If it does not reflect the gravity of the offence, then the CPS can argue that public nuisance would still be a more appropriate charge. And those are the, a very quick run through, and obviously behind each of those, there is a lot more detail for each offence. The common defences, I was asked to talk briefly about necessity. So one defence, which again you will be familiar about, is that you honestly and reasonably believe in harm. That harm has to be serious harm or risk to life. That belief is reasonable, and that your action is reasonable and proportionate. The bars to necessity is what you'll hear the prosecution talk about constantly, is imminence and nexus. And they will say, well, what does sitting in the middle of a road, what does damaging a building have to do with preventing the climate crisis? Because there's no imminence and there's no nexus. Well, we all know that the climate crisis is happening here and now. And the idea that it's not imminent is firstly a misnomer by the prosecution and misleading. But they misunderstand, we say, the test on necessity. The test is one of necessity, not one of imminence. And there is a case of Abdi Hussein that we often quote, which talks about that. If Anne Frank had stolen a car to escape from Amsterdam and had been charged with theft, the tenets of English law would not have denied her a defence on the ground that she should have waited for the Gestapo knock on the door. And that's what I've often used in court, really, that what the test really is about is the inevitability unless action is taken. And hence, it's within the rights of defendants to take the action that they did take, provided it was reasonable and proportionate, and the courts can determine that, and that necessity is still available to defendants, even in climate crisis cases. The other problem, though, is this: it's what's called the functioning democratic state, and that comes from the case of Jones. In Jones, defendants were protesting about the Second Iraq War in 2003. They had invaded a American airbase, cut through the wire, so there was criminal damage, aggravated trespass, and they said they were justified in doing so. It was necessary to do so because they were seeking to prevent an illegal war from occurring. And one of the judges gave a very long speech, which he didn't have to do, but talked about the fact that citizens who apprehend breaches of the law should call the police, the state, not take the law into their own hands, because we live in a functioning democratic state. And so it is not for citizens to behave like what he called the only sheriff in town. Now, that is a problem in necessity defences. I think that we should certainly think about doing more about that, about how we challenge that. Because what clients will say to me is that the functioning democratic state does not work when it comes to the climate crisis. Heathrow being the classic example, where politicians were voted in on the basis that they would oppose the third runway and then promptly try to implement it. And so trying to show, and it is difficult because the courts will not let you do this, but trying to show that in a particular area, the democratic state is weaker than it is in other areas. So nobody doubts the functioning democratic state to impose lots of laws and to enforce lots of laws and to prevent harm to citizens. But has the functioning democratic state managed to find a solution to the climate crisis? Well, obviously not. And hence, I think some more of our speeches may be directed in future cases with regard to that and try possibly the courts to allow some evidence about how that works. But you all know that in magistrates' court cases, necessity has been ruled not to be a defense in XR cases, but by the hundreds. It has occasionally worked in Crown Court cases, but even then the judge withdraws the defense. Defendants, for example, in the Shell case, and I know Ian's here and may want to talk about it, say what they want to say and juries can still acquit. But it's certainly something that we as defense lawyers think operates, but we think the prospects of success are very, very low. And we think very impossible really in the magistrates court. But there is an alternative to necessity, and that's the case of Ziegler. And Ziegler's now an incredibly important case, which I'm just going to spend a little bit of time on. So Nora Ziegler and 3 others locked themselves on to each other on a road in the lead up to the Excel Arms Fair. And the Excel Arms Fair goes on every 2 years in East London. It's the largest arms fair in Western Europe, and it has a history of selling not only weapons which just by themselves shouldn't be sold anyway, and we shouldn't be encouraging it, but weapons that are sold to regimes that commit crimes against humanity and weapons themselves that have been classified as unlawful or torture weapons. And the defendants felt very strongly about this and locked on to try and prevent the fair from setting up. The High Court in of itself, this went to the Magistrates Court, and the Magistrates Court acquitted them. They said that this was a reasonable use of the highway and that the defendants were entitled to do what they did because it was a fairly targeted action. And that gets away from the old law for obstruct highway, which was a road, its primary purpose is to pass and repass. And when you are in the middle of the road and you block people, then you are prima facie, really, you're up for committing an offence. And the High Court said, well, actually, that's wrong. There's no trump rights. You have to look at a balance between different people's rights, the right to use the highway versus the right to protest. And that the tests in Ziegler, were you exercising your right to free speech under Article 10 and 11? Was there an interference? Is that interference prescribed by law? Is it in pursuit of a legitimate aim? And is it necessary in a democratic society? And these are the tests that still apply now. Ziegler did go to the Supreme Court, which I'm going to come on to, but they endorsed what the High Court said about what the test is. Is the aim sufficiently important to justify interference with a fundamental right? But the real one is this. Is there a fair balance between the rights of individuals and the general interests of the community, including the rights of others? And that's what's called the proportionality test. The proportionality test really for the state or the police, have they got the balance right? Because when they seek to move protesters on who are in the middle of the road, or when they arrest them, or when they impose Section 14 orders, what they're doing is interfering with your right to free speech. And they can only do that if they behave in a reasonable and proportionate way. And what happened in the High Court was that the High Court, having given all of this beautiful rhetoric about the importance of free speech, in effect then said, but if you deliberately protest someone, if you deliberately protest in the middle of the road, inevitably you're going to be on the wrong side of that balance, and the police will be justified in interfering with your right. So it was a way of reframing the law in theory, but then in practice, going back to what the old law was, because if it was deliberately obstructive, they said you were going to be guilty. So we appealed Ziegler in the High Court and went to the Supreme Court. And that was announced in June. And the Supreme Court, hugely important, said that deliberately obstructive protests can still have the protection of Article 10 and 11 of the European Convention on Human Rights. Doesn't necessarily mean that it always will, but each set of facts must be examined, and you can't simply automatically say that because it is deliberately obstructive, that means you're going to be guilty of the offence of obstruct highway. And Ziegler sets out a few factors for the court to consider. So the importance of the precise location. Why are you protesting in that particular area? Was it a targeted protest? The duration, the extent of the highway obstruction, the extent in which it interfered with the right to others, whether it gave rise to any disorder, whether the views give rise to whether the views giving rise to the protest relate to very important issues. That's quite an important section for XR cases, for how we are allowed to give evidence, or how you are allowed to give evidence. Because when you're challenged by district judges in future about, well, I don't need to hear about all of this, about the climate crisis, what we can say to the court is, well, you do, because the Supreme Court specifically said that one of the issues that you need to consider is whether it was a very important issue, and what can be more important than the issue that you are seeking to bring to the public attention. And so that's a way of giving some of the same evidence that we would have done in the necessity defense, but under a new guise in what we call the Article 10 defense. So Ziegler is hugely important, but these factors can be difficult for some XR protests, because Ziegler, the protest lasted a maximum of 90 minutes. Some XR protests clearly last much, much longer. And the extent to which the protesters obstructed the highway. Again, in Ziegler, the court found that although they'd blocked one entrance to the XL Centre, vans could have got in another way. And that was one of the main reasons why the defendants got acquitted. So that if people are prevented from using a particular route in totality, then it might go the other way. But it allows us to argue these points, whereas before in the High Court, it meant that the district judge tried to shut things down. And so it's certainly something which you may have seen in the press, and some of you may have been affected by the cases, the appeal cases that are being heard in the Old Bailey, where the police have dropped quite a few of the appeals from September 2020 in relation to obstruct highway, because they've accepted that the evidence that they had collected from magistrates' court trials perhaps doesn't quite meet these tests. Now, it doesn't mean that they think that they wouldn't have a case ever, but what it means is that in future, they know that they've got to collect evidence about this. In particular, possibly, they've got to get better evidence about the extent of the actual interference, about what the level of disruption was. Did anybody complain about it, for example? Have they got any evidence of that? And secondly, what the actions of the individual were. How long were they present for? Do they have any evidence of that? Lots of the previous cases from the 3 rebellions before, they didn't have evidence. As I say, they might have to go back and try and get it. But that's going to be quite interesting to see how they now approach Ziegler, particularly bearing in mind demos coming up, how they approach the convictions that have already taken place. And my colleague Mike Schwartz has written to the DPP asking for assurances that some sort of review is en route in relation to all of the convictions that have occurred that take into account these tests. So the significance of Ziegler can't be understated. There is a risk here, and that is this, is that Ziegler is, in terms of the right to protest, unremittingly good news. And it's very rare that we can say that in protest law at the minute. Now, what the risk is that if there are further appeals on other cases, that the courts will start to chip away at that. And they will say, well, if you go to the Court of Appeal or you go to the High Court and you say, well, I know that's what they said in Ziegler in the Supreme Court, but actually this is slightly different. And so we're going to distinguish that and then try and give an alternative line of authority to try and chip away at the rights that Ziegler has given. Now, this is a balance because there's no point having rights unless you can enforce them, unless you can take it to appeal if the lower courts get it wrong. But equally, we do need to be careful that appeals aren't taken which undermine Ziegler in a way that will be damaging in future. There's inevitably a risk of that in some appeals because some appeals you just have to take. And, the Court of Appeal is a lot more conservative than the Supreme Court. And it may well be that they try to restrict this a bit. What I was meant to talk about, which I'm just going to end on fairly briefly because I've already gone on a bit, is the Police Crime Sentencing and Courts Bill. And this is as serious an attack on liberty and the right to protest as has existed for 40, 50 years, since certainly the 1986 Public Order Act. Public order legislation is quite interesting to look at in history because the 1986 Act was basically brought in after the miners' strike. And lots of the provisions you can see were things that the police had been complaining about current public order legislation. And the 1986 Act was then brought in at the behest of the police to make it easier to crack down on things like the miners' strike in future. And indeed, that goes back to the 1936 Public Order Act, which was brought in at the time of Cable Street and so on. And the Police Crime and Sentencing and Courts Bill could be called the XR and Black Lives Matter Bill. It has been specifically brought in to try to stymie and shut down XR protests and Black Lives Matter protests. And before you get into the detail, I think that is a remarkably dangerous, disgraceful thing for a government to do, which is to bring in legislation to try and prevent protests by what might be perceived as your political opponents. It would never get passed in the United States. Just use that as an example because of the First Amendment protections are greater. What it allows the police to do is to set start and finish times for assemblies. It allows them, somewhat amazingly, to set noise limits so that if your protest is too noisy, they can try and put a condition to that. And the whole purpose of protest is to draw attention. That's the whole issue of it. And the rules on Section 12 and Section 14 apply to a demo by just one person. Previously, obviously, you needed two to form an assembly, and that's in a response to the previous XR rebellion of one. And that's precisely why they've brought that in. Intentionally or recklessly causing public nuisance. What the police want to do is they wanted to use public nuisance more often. And for reasons that I've already referred to, they couldn't. And so the way around that is to get Parliament to pass a new law called public nuisance, which includes the fact that you cause serious annoyance. And that is punishable by 10 years imprisonment, as is, as you will all know, damaging a historical statue or monument. In fact, it's not even just a historical statue or monument. If you damage the flowers that are next to the monument, then the maximum prison sentence would be 10 years. Now, I don't think anyone would ever get that, obviously, but by Parliament trying to increase the seriousness of these offences, then they're trying to give a signal to the judiciary that you should at least try and imprison people. What all of this is quite insidious is because they know it's not going to stop the types of protest that they want them to stop. It's not going to stop perhaps some elements, some committed XR activists. It's not going to stop some of those Black Lives Matter protests or activists. But what it is seeking to do is try to undermine and scare people from joining any protest and from joining any XR or BLM protest. Because if you haven't been to a protest before, then if you suddenly think that these are the risks that you will run, then what it's trying to do is to scare off as many punters as they can, because they want to shut down these protests. And as I say, to me, I think that's pretty disgraceful and pretty cynical. I think there is a great risk that this bill is going to pass because of the majority that the Conservatives have got at the minute. We can only sort of redouble our efforts to try to prevent it from being passed and to continue to campaign against it. So that is a very quick overview, and I'll stop sharing for a second and leave it open to discussion and questions.
Thank you.